Welcome back. Now let's continue the conversation on the controversy between the EFCC and the former governor of Kogi State, Yahaya Bello. Now, so much has been made about the judgment of that Kogi court that Yahaya Bello actually has been citing, saying it prevented the EFCC from arresting, prosecuting, or doing anything at all to him. Let's take a listen to the EFCC chairman now read portions of that judgment. Take a listen.
I will read to you the last 2-3 paragraphs of his judgment. He said, I am under no illusion that under the laws of this country and having regard to the provisions of the EFCC Act 2004, the Commission cannot be restrained from carrying out criminal investigation and prosecution of any citizen of this country. However, the exercise of these powers is subject to the overriding provisions of the Constitution or any subsisting order of court, and he quoted some judgments, IGP versus Uba, and so on. And he went further to say that the applicant having established, that was Yahaya Bello, established infringement or threatened infringement of his right. He didn't say infringement, or threatened infringement of his right by the respondent, which was EFCC, is now entitled to benefit from the long-standing principle and legal maxim, ubi jus, ibi remedium, as it is central to the cardinal principle of administration of justice, that where injury is established or imminent, there must always be a remedy. And he quoted some other judgments. The applicant, no doubt, is entitled to the grant of some protective reliefs. While I am inclined to grant the orders sought by the applicant in this application, I can only grant them subject to what is permissible under our laws. It has been repetitively made clear in this judgment that the respondent cannot be restrained, as EFCC, from exercising its statutory mandate to investigate and prosecute persons or authorities reasonably suspected of having committed financial crimes as obligated under its Establishment Act. Accordingly, I will make no such order. And he gave us some citations. And if I may add, prosecution. Now, looking at the orders sought by the applicant, I am inclined to grant them subject to some alterations, which in my view will meet the justice of this case, as in following terms. An order is hereby granted, enforcing the fundamental rights of the applicant, that was Yahaya Bello, to liberty and freedom of movement and fair hearing, by restraining the respondent, that was EFCC, by themselves, their agents, servants, or privies, from continuing to harass, threaten, to arrest or detain, or in any manner whatsoever arresting, detaining, or persecuting the applicant, or I think he wanted to write prosecuting the applicant, on the basis of criminal charges now pending before the Federal High Court. We had filed our charges there. Now, without prejudice to the power of the said Federal High Court to make any order as it may deem just in the determination of the rights of the applicant and the respondent as may be submitted to them, to her for consideration and determination. Another is hereby granted directing the respondent to bring before the said Federal High Court. It was Kogi State High Court that directed the EFCC enforcer to go and file a charge against him, as against what is being touted out there.
Well, that's the EFCC chairman, Olaolu Koyede, reading portions of that judgment now of the Kogi State High Court. Joining me on the program now to speak more on this is Evans Ufeli, who is a legal practitioner. Evans, thank you very much for your time. Help us to understand this argument, the argument of Yahaya Bello and, of course, that of the EFCC. Yahaya Bello claiming that he has a court judgment that prevents the EFCC from doing anything to him at all, arresting him, touching him, or doing anything at all. And that's the reason why he's so far failed to honor the invitation of the EFCC and has done everything to evade arrest. And then you hear the EFCC making this argument as well.
Yes, the order that was granted by the High Court of Kogi State is one that is tied to the fundamental rights of Yahaya Bello, which has to do with the fact that in Section 46 of the Constitution, it says that where your rights have been violated, or there's a likelihood that same is going to be violated, or you have a feeling that there's an imminent danger, based on that, you can file to enforce your fundamental rights. Now, the High Court granted that order on the basis of the fact that he's been harassed, he's been threatened, and he's doing all that. And the court now said, okay, you know what? Do not harass him, do not arrest him, let him enjoy his fundamental right as a citizen of the country. However, the Supreme Court have said repeatedly that the court, have no right or power whatsoever to preclude or make an order to stop an agency from, its constitutional duties under the law. Now, where the EFCC got it wrong is where they continue to insist on going to his house, even after there's a standing court order to prevent that, continue to, go there to harass and to create sin. That is where they did that on the basis of the fact that they also obtained an order of the Federal High Court.
High Court, yes.
Okay, yes, the Federal High Court to that effect. But at the time they obtained that order from the Federal High Court, the one on the State High Court have not been vacated. And both courts have, concurrent jurisdiction. Okay, because they are both concurrent, none of them can actually be subject to the order of the order. But the first in time, meaning that the order that was first procured is supposed to supersede the one that was procured later. So what the EFCC ought to have done was not to arrest him because there's a substituting order not to embarrass, harass, or whatever. They should have just gone ahead to file their charge and look for a way to ensure that the charge sheet is served on him, either by personal means or by substituted means. Then when they get to court and it does not show up, because in criminal prosecution, it's not compulsory you must arrest the suspect or the defendant. It's not compulsory. What the EFCC wanted to do was to arrest him, take his statement, then go ahead to charge him proper before the court. But that process is no longer possible because of the order you already have at the State High Court. Okay, what you should have done, the order did not say you should not charge him. If you look at it, harassment, intimidation, those are the issues. If you look at that judgment, you will not see where the court said that he should not be charged. Okay, so now you have that window. All you need to do is to charge him. The EFCC ought to have charged him, serve him a copy of the charge sheet, or serve to his counsel, as the case might be. Then the EFCC now will wait until the date set by the court for the determination of that case.
Which is exactly what has happened now. Which is exactly what has happened now.
Yes, which is exactly what has happened. You understand that EFCC also got it wrong by going to his house again when it has already filed an appeal against the first order that was procured by the Kogi State High Court. Now, having submitted yourself to the jurisdiction of the Court of Appeal, which they have withdrawn now, by the way, they have withdrawn that now, by the way. Having submitted yourself to the jurisdiction of the Court of Appeal, you ought not to then go and start to make sin or create sin, because when you submit yourself to the jurisdiction of the court, ordinarily in law, parties are supposed to maintain status quo so that the higher court, which is the Court of Appeal, will not determine whether those orders of the State High Court were validly entered or not. Okay, so the EFCC actually acted outside the law, largely outside the law, and that is why they have given Yahaya Bello a lot of defense because of the way they are going about it. They are not supposed to go to his house and start to create sin, having already filed an appeal to that effect, and that is where they actually got it wrong.
Okay, now help us to understand. You heard the EFCC chairman, of course, during his briefing, saying that he invited Yahaya Bello to come. When an individual is invited to come in that manner now, I mean, shouldn't the individual just honor the invitation?
Yes, ordinarily under the law, he's supposed to honor the invitation, okay? But he failed to honor that invitation, does not call for a public scene, going to his house and all that because of the order. Had it been there was no order at all, okay, if he fails to come, then you can go for arrest. That's the procedure. You understand? In the absence of an order, you must do that. Then the EFCC now went ahead and started making statements like, we gave him opportunity to come. The EFCC chairman said he wanted him to even come to his office to take all that, and that is creating another issue, because in doing that, you are telling the public that you have two procedures, one for the elite and one for the citizens. And that is not tidy at all. The EFCC is supposed to be above board. No one is saying that the EFCC should not arrest Yahaya Bello, but they must, come within the confines of law and procedure, given that it's a high-class agency of government in this country that we all need to support so that they can do their job and do it effectively. But when they go outside of the confines of the law, that is, the extant law that created the commission itself, then it becomes untidy, and all this will be used against them when trial fully commences. And the truth is that, let the public know that the fact that they are not chasing Yahaya Bello does not automatically translate to the fact that when they get to court, the EFCC will actually win the case on that reference, or whether Yahaya Bello will win the case on that reference, because procedures must be followed. And if you have court orders against an institution, and the institution want to prosecute, the institution must be careful not to violate the court order you already have, because in law, they say that he that comes to equity must come with clean hands. If you are filing a case, you want to prosecute someone, you must ensure that you are not also found wanting in breaking the same law that you have now brought a defendant to, prosecute. So the fact is that the EFCC must make this tidy, make it workable. People are asking whether EFCC really want to prosecute or not. This is not the first time that a person have gotten an order against the EFCC for all that. But no court will grant an order against the EFCC not to charge. Okay? Charge does not mean arrest. Charge does not mean intimidation. Charge does not mean violating fundamental rights of anybody. So you must charge. And when you charge, the next thing, once you're able to serve the adverse party, that's fine. If he likes, let him come to court. If he likes, let him not come.
So essentially, you are saying that if the EFCC, as part of its investigation, wants that individual it plans to charge now, wants him to come and, as part of its investigation to be investigated, the EFCC hasn't got such a right.
No, the EFCC have a right. No, I'm saying the EFCC have a right to invite, okay? To invite, and but in the event that you invite someone and they refuse to come, what the law says is that they can now go and arrest. That's in the event that there's no court order precluding the EFCC from doing that. But since there's a court order, all they needed to have done is to charge him, ensure that he's served, either in person or through substituted means or through his counsel. Then, if he comes to court in the next adjournment, fine. If he does not, the case will proceed. The prosecution will go on with his case. And the law is that if you do not show up, and even in civil cases, they'll tell you, if you don't come, the matter will continue undefended. And the allegations and all that, if you do not come to defend,
so how does the EFCC then take the statement of this individual?
Yes, that is the question on that reference, because his statement is paramount in the case on that reference.
Yes. So the reason I'm asking you that is because here you have a court that says don't touch him, don't invite him, don't do anything at all. So how do you take his statement?
The order did not say he should not be charged.
Yes, I know. The order did not say he should not be charged, but it says he should not be arrested, he should not be touched, he should not be invited at all.
He need not be arrested to have his charge taken. He need not be arrested to have his charge taken, because the law is this in that section 36 of the Constitution. The court will give you an opportunity for fair hearing. If you do not utilize the opportunity of fair hearing, the court will continue its proceedings. Because the truth is that His statement is evidence, okay? It's his evidence. It's his own statement. So if he does not come to give his statement, the court will continue with what it has, because the law is that an opportunity is given to you for fair hearing, for you to come and say your side of the story. It's an opportunity. If you do not take the opportunity, the court will proceed.
You don't seem to understand what I'm saying. I'm saying it's just like when the police invites you to come and give a statement over an issue, and you choose not to go. How does the police get your statement?
That's what I'm saying. When they invite you, it's an opportunity to take your statement. That's fair hearing. Fair hearing is that you invite him to take his statement, to hear his own side.
If you refuse not to, go on.
If you refuse, the court will proceed. As long as the evidence is there that you were invited to have your side, your own side of the story heard, and you turned it down, the court will proceed. There are a lot of Supreme Court authority on this. You see, fair hearing is not that you hold it as a toga against prosecution. You cannot hold it as a toga against prosecution. What the law is that you are given an opportunity to come and air your side of the story. You are not. If you do not take the opportunity and air your side of the story, the court will proceed and actions will be taken against you. As long as there's enough evidence to show that you were invited, you did not come to give your own fair hearing to the matter. That is it. The court will proceed.
Let me ask you a final question. Do you look at this whole issue? The question you ask is, do you think the judiciary is also helping matters when it gives, continues to give orders like this? I mean, we've seen this kind of order giving, like in the case of the former governor of Rivers State. I'm talking about a one-time governor now, Odili. There was a report then that there was that a court gave a perpetual injunction against his arrest and prosecution and all of that. So I'm just wondering, when the judiciary does this, does it help in the fight against corruption?
It doesn't. It doesn't. The order for perpetual injunction was actually wrong. And I do not know why it was not appealed against and upheld or vacated. It was wrong, because what you are saying is that in the case under reference, that case of Peter Odili, that none of the security agency can arrest him in perpetuity as regards that case. That's very, very wrong, okay? But in the case of giving conflicting orders, the people that will be blamed and held responsible are the lawyers and the counsels. The counsel who is aware that a court somewhere have given an order. It went to another. In this case, EFCC should be blamed.
But what I'm asking, the reason what I'm asking is, I'm basically particularly looking at the order of the Kogi State High Court.
Yes.
That's what is in reference here. Does it help? Does it help in the fight against corruption?
It doesn't at all. It doesn't, because what you are doing is you are indirectly twisting the EFCC. You are holding them to ransom, not to prosecute. Whereas there's an extant law in the country that created the EFCC and empower it to investigate, to arrest, and all the things you have listed are the powers given to the EFCC by law. All the things you are listing in the only thing that is not there is charge. You understand? So how would the EFCC now function and fight corruption if you are going to have orders restraining them from doing their job? And the Supreme Court have said this repeatedly, that you can only have an order against EFCC, for example, when they abuse the authority of their office. You can get an order to that effect to prevent them from abusing their powers. But you cannot procure an order, okay, to stop them from carrying out their lawful duty. In that case, it means that the law have given them a power to do what they ought to do, while the court is taking away that same power from them at the same time. So it is the abuse, and that is why if you look at that case, the Kogi State High Court ruling, it's a fundamental right case, The fundamental right of citizens must be protected according to Section 46 of the 1999 Constitution. However, where the security agencies have abused or they are likely to abuse their powers with the way they are going and fronting, the court can make an order to prevent them from that abuse. but not an order to stop them from carrying out the functions of their office.
Because to be candid, I find it very funny that the court would say, look, don't touch, don't even do anything, don't. Especially when we're talking about a criminal matter here. Well, what can I say? Ivan Sufeli, thank you very much for coming on the program, and thanks a lot for your time. I will take a short break and we'll be right back.
Opinions are free, facts are sacred, but truth is universal.
How, in practical terms, can we, for instance, de-escalate the tension?
President must see himself as the President of the Federal Republic.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, and use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.